You shake hands on a deal, but is that actually a contract? English law says a binding contract needs three things to click into place, and if any one of them is missing, there's nothing the courts will enforce. Think of contract formation as a three-item checklist: offer and acceptance, consideration, and intention to be legally bound. All three must be satisfied. Tick all three boxes and you have a contract. The first element is agreement, broken down into offer and acceptance. An offer is a definite proposal made with the intention that it becomes binding the moment the other side says yes. Distinguish it from an invitation to treat. An invitation to treat is merely an invitation to make an offer, and it does not bind the person who made it. In Fisher v. Bell, the divisional court held that a flick knife displayed in a shop window with a price tag was an invitation to treat, not an offer for sale, so the shopkeeper was not guilty of offering the knife for sale under the relevant statute. The same logic applies to goods on supermarket shelves and advertisements generally. Acceptance must match the offer exactly and must be communicated to the offerer. Any attempt to vary the terms is not acceptance, it is a counteroffer, which destroys the original offer entirely. That is the rule from Hyde v. Wrench, where the defendant offered to sell his farm for £1,000. The claimant counter-offered £950. The defendant rejected that. The claimant then tried to accept the original £1,000 offer. The court held there was no contract. The counter-offer had killed the original offer dead. The second element is consideration. For a contract to be enforceable at common law, each party must provide something of value to the other. The courts have consistently said consideration must be sufficient, meaning it must have some recognizable legal value, but it need not be adequate, meaning the courts will not second-guess whether the party struck a fair deal. Two important limits apply. First, past consideration is no consideration. In Roscola v. Thomas, the claimant bought a horse, and the seller then promised the horse was sound. The court held that promise was unenforceable because the only consideration the buyer had given, the purchase price, was already passed by the time the promise was made. Second, you cannot use performance of an existing contractual duty as consideration. In Stilkvåg Myrick, two sailors deserted a voyage. The captain promised the remaining crew extra pay to sail the ship home. The court held the crew could not enforce that promise because they were already contractually obliged to sail the ship. They had given no fresh consideration. Williams v. Roffey Brothers, decided in 1991, later allowed a practical benefit to count as fresh consideration in some circumstances, but that is a refinement, not a reversal of the basic rule. The third element is intention to create legal relations. This is assessed objectively. The question is how a reasonable person would interpret the party's conduct, not what either party privately intended. English law applies two rebuttable presumptions. In social and domestic arrangements, the courts presume there was no intention to be legally bound. This is the ratio of Balfour v. Balfour, where the Court of Appeal held that a husband's promise to pay his wife a monthly allowance was unenforceable. The parties were not dealing at arm's length, and the court should not regulate domestic agreements of that kind. The presumption is rebuttable. In Merritt v. Merritt, a separated couple made a written agreement about the matrimonial home, and the Court of Appeal held it was intended to be binding, distinguishing Balfour on the basis that the parties were estranged and negotiating formally. In commercial arrangements, the presumption runs the other way. Legal intent is assumed. That presumption too can be rebutted, typically by an express clause stating the agreement is binding in honor only, as in Rosenfrank co. v. J.R. Crompton. Check your understanding. Priya emails Tom offering to sell her laptop for £400. Tom replies, "I'll pay £350. Tom then immediately says, "Actually, I accept your £400 offer." Is there a contract? Option A, yes. Tom accepted within seconds, so the original offer still stands. Option B, no. Tom's counteroffer destroyed Priya's original offer. Option C, yes. Minor price negotiations do not affect offer and acceptance. Option D, no. Email acceptance is never effective in English law. The answer is B. Under Hyde v. Wrench, Tom's counter-offer of $350 destroyed Priya's original offer entirely, so there was nothing left for Tom to accept. To form a binding contract in English law, you need all three elements: a matching offer and acceptance, consideration from each party, and a mutual intention to be legally bound. Miss one, and the courts won't enforce it. Your modules, mapped to your uni. Explainer videos for every topic. A tutor that knows your course. Essay writer for your essays and graded. Case briefs, flashcards, annotations. Try it free for 7 days. Link in the description.